नहीं नहीं हाँ ये चाहिए वो जजमेंट्स नहीं चाहिए.
Yes. Aditya, start.
A very good evening, everyone. Welcome to the SCORA lecture series in our ongoing lecture series for the AOR aspirants for the upcoming AOR exams. Today, we have with us a senior advocate, Mr. Anupam Laldas, who will be speaking on the subjects of leading cases, where he'll be covering the inherent powers and curative petition, the AR Antulay judgment, Rupa Ashok Hura judgment, Nandini Sundar judgment, and the Rita Soren judgment, and on Article 14, 19, and 21 of Constitution of India, which covers under the Maneka Gandhi judgment. So before we start this lecture, I request my senior colleague, the Vice President of SCORA, Mr. Amit Sharma, sir, to kindly give a brief introduction of our today's speaker. Please, sir.
Well, good evening, all of you, and good evening, Mr. Anupam Laldas.
Good evening.
Let me first say that we take pride in organizing the SCORA lecture series for the AOR aspirants, and our endeavor is to extend as much help as we can on behalf of Supreme Court Advocates on Record Association to all the AOR aspirants. So, my all the best wishes from SCORA to all the AOR aspirants who are due to give their papers from 16th of June onwards. Now, Mr. Das, as rightly mentioned by Mr. Giri, he will be speaking on some of the cases which have been selected in the category of leading cases, and the details have been already shared. So let me give a brief introduction of Mr. Anupam Lal Das. He's a first generation lawyer, uh, and before he did his higher studies from St. Xavier's School, Hazaribagh. Thereafter, he did his graduation from KMC Tirurimal College, Delhi University, and then thereafter he did his LLB from Campus Law Center, that also is in uh, Delhi University. Mr. Das has been practicing for almost more than 3 decades, if I may say so, and he has practiced in almost all the branches of law. And I must say that his clear understanding of laws, meticulous preparation, and his absolute fair presentation of a case, and that is what makes him stand on a different footing in courts of law. If I may use a cricketing term for Mr. Das, I can surely say that Mr. Das has almost 90% strike rate in the Honorable Supreme Court of India. So I would now request Mr. Anupam Lal Das to kindly proceed with the lecture.
Thank you. Thank you so much, Mr. Sharma, for those kind words. Now, 90% strike rate in the Supreme Court would obviously mean 90% of dismissal and not the other way around. So, before I start my lecture, I must compliment SCORA for doing such a wonderful lecture series with so many eminent speakers. And it is something which we did not have in our times. And it really helps candidates who are obviously all lawyers in preparing for this very, very challenging exam. So kudos and full marks to SCORA for this lecture series. And in fact, without wasting, because I was also a little late, so without wasting any further time, let's I think come back to our lecture series. So my topic for today, and
Yes.
in fact, I take pride in telling all the people there, the entire audience, that this paper, which is the paper on leading cases, is a paper, if you are able to prepare for this paper, then you become a lawyer in the true sense of the word. Because never in your life you would ever read about 50, 60, 70 constitution bench judgments from 1950s to 2025. This is the only chance that you get when you're preparing for leading cases. So I'm sure that all of you would have already started burning midnight oil. So I would be starting from a case. I don't know whether it's a part of the list of cases in the leading cases or not, because when I mention Maneka Gandhi, it is impossible to mention A.K. Gopalan versus State of Madras. Now, for the reason that this is a case of 1950, but this case actually sowed the seeds for the great case which conceptualized the trinity of articles, that's 14, 19, and 21. Now, whenever you are attempting Maneka Gandhi, you must write, in my assessment, A.K. Gopalan, because then the examiner would know that you know the history of Maneka Gandhi, how laws have actually evolved. And 1950, obviously, this was one of the very first Constitution Bench judgments. Now, it is also known for the famous dissent of Justice Fazal Ali. And this was perhaps the first dissent in any Constitution in bench cases of those times. So this is the first dissent. Now, when you attempt an answer, a question may ask of you something. So therefore, the first important thing is that you should be aware of the facts of the case. Now, when you are attempting Maneka Gandhi, very broadly you should know the facts of A.K. Gopalan, which is a 1950 case. So A.K. Gopalan was a prominent communist leader who had been under detention since December 1947 under various orders issued by the Madras state government. Now, in March of 1950, if my memory serves me right, while still in custody, he was served with another order under Section 3(1) of the then newly enacted Preventive Detention Act. Now, this act allowed the central or the state government to detain individuals, to prevent them from acting in a manner prejudicial to what was understood then to national defense, foreign relations, public order, maintenance of essential supplies, etc. So he filed a writ of habeas corpus under Article 32(1), challenging the legality of his detention. Now, obviously, all of you would know that when there's a law in place, maybe a habeas corpus was perhaps not the correct remedy. But the issues raised in this judgment was whether the Preventive Detention Act violated 14, 19, and 21. And what was the meaning and scope of procedure established by law in Article 21? And did it include the principles of due process of law? Now, what was held in that case was the interpretation of procedure established by law. The Supreme Court actually adopted, with all humility at my command, I must say, was a very narrow and literal interpretation of procedure established by law. And it held that this phrase meant any procedure enacted by a competent legislature, regardless of, please note this, fairness or reasonableness. And the court rejected the application of due process of law concept, which was there in the American context. And it limited judicial review of legislative action, even concerning personal liberty. This meant that as long as the procedure was legally enacted, even if it seemed arbitrary, it would satisfy the test of Article 21. Now, it also held that these three articles were mutually exclusive. It held that Article 19, which gives various freedoms like speech, movement, etc., did not apply to cases of preventive detention. Now, there was a great dissent. We have seen that often, as time goes by, dissents at times result in that dissenting opinion actually becoming a majority opinion in a later case. And this is how laws evolve. And Justice Fazal Ali gave that dissenting opinion, which actually was an early interpretation of the fundamental rights, and it criticized the narrow interpretation of Article 21 as given, and in the A.K. Gopalan case. It also commented on the root doctrine of mutual exclusivity between Articles 19 and 21. So now there was a tectonic shift in jurisprudence later in Maneka Gandhi versus Union of India. Now, in this case, just give me, yeah. In this case, this was a 7 judges bench sometime in the year 1977. So in this case, Maneka Gandhi, who was an activist, was issued a passport in 1976 under the Passport Act. Now, the very next year, and all of us, I mean, all of you would also know that those were the days of emergency. 1975 emergency was declared. So in 1977, sometime in 1977, the regional passport officer, New Delhi, issued an order impounding her passport under the Passport Act, citing public interest as the reason. Now, Maneka Gandhi immediately requested for a statement of reasons for this order, as provided under Section 10 of the Passport Act. However, the Ministry of External Affairs refused to provide the reasons, stating that it was in the interest of general public. Now, aggrieved by this arbitrary action, Maneka Gandhi filed a writ petition under Article 32, challenging the impounding of a passport and refusal to provide reasons. She contended that the government's action violated her fundamental rights under Article 14, 19, and 21. Now, in this judgment, the courts perhaps for the first time recognized these trinity of rights guaranteed by these 3 articles. Now, the issue raised in this case was whether a right to travel abroad is a part of personal liberty guaranteed under Article 21. Please see that it was personal liberty for travel was treated as a part of Article 21. And the true import and meaning of procedure established by law in Article 21. And as I had said, indicated in the early part of my lecture, that A.K. Gopalan had taken a very narrow and pedantic view insofar as procedure established by law in 21 is concerned. So, in Maneka Gandhi, another question that was raised was whether impounding of her passport without providing reasons or an opportunity of being heard violated the principles of natural justice and therefore her fundamental rights, and whether Section 10 of the Act was unconstitutional. Now, for the first time, the Supreme Court, the majority opinion, gave a very expansive interpretation of a very welcome judgment of personal liberty, and it unequivocally held that the right to travel abroad is a part of personal liberty, and they overruled the narrow interpretation of personal liberty as adopted by the Supreme Court in A.K. Gopalan. And it also held, and please, you must, in fact, whenever you're writing an answer, there are keywords. Like, for instance, in this case, keywords are personal liberty and procedure established by law. If you highlight these keywords, then the examiner would know that you know what is the soul of the judgment. And in this case, the Supreme Court pertinently held that procedure established by law must be just, fair, and reasonable. And the court overruled the interpretation of procedure established by law in A.K. Gopalan. It also delved upon the interrelationship between Articles 14, 19, and 21, which we now often refer to as the Golden Triangle. It also rejected the doctrine of mutual exclusivity established in A.K. Gopalan. It held that, please understand, this is again a very important expression, that 14, 19, and 21 are not watertight compartments, but are interlinked and form an integrated scheme or a golden triangle. Any law infringing upon personal liberty under Article 21 must also satisfy the requirements of Article 14, which means non-arbitrariness. Article 19, you have a host of personal liberties, freedoms, granted under 19, and then you have restrictions imposed under 19. But these restrictions must be reasonable restrictions. It means that a law restricting personal liberty must not only prescribe a procedure, but that procedure must also be non-arbitrary, and the restrictions imposed must be reasonable. Now, one very important thing also happened was that it included natural justice, which is right to be heard as an integral part of procedure established by law under Article 21. So even if it is not provided for in a statute, it must be read in that statute. So it held that impounding of her passport without giving her an opportunity of being heard was a violation of natural justice, which made the order arbitrary and illegal. It also expanded on the concept of post-decisional hearing, allowing for a hearing after the initial decision in urgent cases, provided it is followed by a meaningful opportunity to be heard. Now, I am for, my personal view is that post-decisional hearings normally do not result in a fair decision, because the authority has already decided against you. And it is very unlikely that you would succeed in a post-decisional hearing where the authority has already made up its mind. I mean, that's completely my personal view. Now, the court did not strike down Section 10 of the Act as unconstitutional in toto, but it said that the requirement of fair procedure and natural justice must be read in that section. So this was a revolutionary shift in fundamental rights jurisprudence, and it is considered as a watershed moment in Indian constitutional law. Now, the judgment ushered in an era of judicial activism with the Supreme Court. Please understand those days and those times. Actively reviewing legislature and executive actions to ensure compliance with constitutional principles of fairness, justice, and reasonableness. Now, many of my friends would recollect ADM Jabalpur, etc., those days where very strong judges also sort of sided with the executive, and Justice Khanna's famous dissent in ADM Jabalpur. So you would also be justified in just mentioning ADM Jabalpur when you are actually dealing with Maneka Gandhi. So Gopalan you must mention when you're writing an answer on Maneka Gandhi, and also ADM Jabalpur, to show again the huge shift between A.K. Gopalan. Then you have a very strong judgment in Maneka Gandhi, and then you have this ADM Jabalpur. Now, my next note, my next judgment is on AR Antulay versus RS Naik. Again, a 7 judges bench. So many of you would know that Mr. Antulay was then the Chief Minister of Maharashtra. This is a case of 1987, who faced multiple corruption allegations, and Mr. RS Naik was a political activist who filed a private complaint against Mr. Antulay before a special judge, alleging offences under the IPC as well as under the Prevention of Corruption Act. Now, the special judge initially discharged Mr. Antulay, holding that as an MLA, he was a public servant and required sanction for prosecution, which was not obtained. Now, R.S. Naik appealed this to the Supreme Court. Now, those days, many orders were directly appealed to the Supreme Court because Article 136 says any order, etc. In 1984, a 5-judge bench of the Supreme Court in R.S. Naik versus A.R. Antulay reversed this was 1984, in 1984, reversed the special judge's order and held that MLA was not a public servant requiring sanction under the PC Act. Now, very interestingly, the Supreme Court, in an extraordinary exercise of power, suo motu withdrew the special case from the special judge and transferred it to the Bombay High Court, requesting the Chief Justice to assign it to a sitting High Court judge for expeditious disposal. This meant that trial would be directly held in the High Court, bypassing the special judge. And it basically deprived Mr. Antulay of one tier of appeal to the High Court that otherwise would be available to him under the Criminal Law Amendment Act 1952. So Antulay then challenged the transfer order before a larger bench of the Supreme Court. Now, one really doesn't know how those days such a challenge was maintained, because these days it would have to be referred to a larger bench. But be that as it may, his argument before the 7-judge bench was that the transfer was illegal as it violated his fundamental rights under Article 14 and 21. And the Supreme Court order, the earlier order of 1984, was per incurium. Now, the issue raised was whether the Supreme Court in the 1984 judgment had the power to transfer the criminal case from a special judge's court to the High Court, bypassing the statutory scheme of the Criminal Law Amendment Act 1952, and whether such a transfer deprived the accused of a right to appeal to the High Court, which in turn violated Articles 14 and 21. So the key ruling in this case was that jurisdiction cannot be conferred by a judicial order, and it cannot be created or enlarged by a judicial order, even by the Supreme Court, unless that power is specifically conferred. Now, the court also held that this kind of an order violated Articles 14 and 21. That's equality and right to fair trial in terms of procedure established by law. And it also delved upon the doctrine of per incurium and the power to rectify errors. The court asserted its inherent power to correct its own errors, particularly when these errors led to violation of fundamental rights. It held that 1984 order of the Supreme Court was per incurium, but because it failed to consider the provisions of the Criminal Law Amendment Act 1952 regarding the exclusive jurisdiction of special judges. And a larger bench has the power to revisit the incorrect decisions issued by the smaller benches. Now, it also delved upon the power under Article 142, which is an extraordinary power to do complete justice. And the fact that these powers cannot be used, please note this, it's a very important point, contravenes substantive provisions of law or abrogate fundamental rights. And Article 142 cannot be used to create jurisdiction where none exists by statute or to bypass mandatory statutory procedures. Now, I must, in fact, disclose to whoever is attending this lecture that if you are able to pull out the coal cases, coal block cases, starting from M.L. Sharma, and where the Supreme Court had passed an extraordinary order transferring all the coal block cases to itself and then passing a further order that all the matters would be filed before the Supreme Court. So basically, a judge in Rouse Avenue dealing with a PMLA matter passes an order, for example, rejecting an application of an accused for discharge. You will have to, under the current regime, challenge it before the Supreme Court. And the High Court is completely bypassed. Now, this point was raised before the Honorable Supreme Court, which in one paragraph did not deal with AR Antulay on the ground that this only related to an amendment bill of 1952. So this was under the old act. So now we have a new CRPC, so we will not really consider. So this challenge was repelled in one paragraph. Now all the matters are back to the Honorable Supreme Court and the matters are pending. And I am also appearing in some of the matters, so it would not be proper on my part to comment further on it. But be that as it may, if you are attempting this question, I would also advise that you get hold of Mr. M.L. Sharma's case, and you must cite this case also. That Article 142 to whichever you feel, whether Article 142 was rightly used, wrongly used, that's something that this critique or otherwise is something which is your decision. Now, in this case, there was a dissenting opinion by Justice Venkatachalaya and Justice Ranganathan, where they they wrote on the checks on judicial power. And AR Antulay is a landmark case that established crucial limitations on the powers of even the Supreme Court. It firmly held that judicial directions cannot override statutory mandates and cannot create jurisdiction not vested by law. So this was basically, and then it also talks of limitations on Article 142, which we've already discussed, and fair trial implications, etc. My next topic, my next judgment is Rupa Ashok Hura versus Ashok Hura. So we have broadly discussed this in AR Antulay. We've also discussed on Article 142 and the fact that the power is circumscribed by laws which govern the field. No order under 142 should ordinarily be passed if there is a statute governing the field, even if, it is exercised on the ground that it is to do complete justice between the parties. But that's again my personal view, that 142 should not be exercised contrary to a written statute. Now, this case was a very interesting case, and it interestingly originated from a matrimonial dispute between Rupa Ashok Hura and Ashok Hura. And the Supreme Court, in an earlier decision in 1996, confirmed a decree of divorce between the parties and directed the husband to pay permanent alimony. The wife, Rupa Hura, then filed a review against the 1996 judgment, which was dismissed. In 1997, subsequently, she filed a curative petition arguing that the 1996 judgment and the subsequent dismissal of review caused a grave miscarriage of justice, and that the fundamental principles of natural justice were violated. Now, the central question before the 7 judges bench was whether the Supreme Court possessed the power to entertain a curative after a review was dismissed on the ground of miscarriage of justice. Now, this issue arose because the concept of a curative petition was not explicitly provided by the Constitution or any statute. It was a novel remedy sought by the petitioner in light of the perceived finality of the Supreme Court's judgment after review. Now, you must read this judgment and specifically note the issues raised in the judgment. One was whether the Supreme Court has the power to recall its own final judgment after review has been dismissed. If such a power exists, under what circumstances and within what parameters can it be exercised? Now, these two issues are very important because there is, at least at that time, it was felt that there can't be an open curative petition, and the curative petition must be on very limited grounds. Curative petition, if any. Now, the unanimous opinion was that the Supreme Court possessed an inherent power to recall judgments to prevent miscarriage of justice. Now, there is a now the Supreme Court held in this evolution of curative petition that the Supreme Court had the inherent power to recall its own judgments and orders, even after dismissal of a review petition, if it led to a gross miscarriage of justice. However, the Supreme Court was very careful in pointing out the grounds on which such a curative petition could be filed. And the first ground was violation of principles of natural justice. If the petitioner has been able to point out that he or she was deprived of a fair hearing or an opportunity to present his case before the judgment was rendered was not given, or that the court overlooked a binding precedent or a relevant statute leading to manifest injustice. And the second was basically on the grounds of bias of a judge, if there was a reasonable apprehension of bias on the part of the judge who was part of the bench which passed the judgment, and then fraud. And then it gives out the procedural requirements which you must read, which is certification by a senior advocate with regard to prima facie case, strict grounds. So all these things you will have to read the judgment to find out. Now, while dealing with this case of Rupura, I would very strongly recommend that you look at the forward references also. Like, for example, I can think of the DMRC case, the Delhi Metro Rail Corporation case, where in a curative petition, the court has actually given a new judgment. And basically on the ground of, I mean, there are various grounds, but the ground of a curative petition has been really, really expanded, which appears to be almost like a second bite at the cherry. So you must read this judgment and you must cite this judgment when you are dealing with Rupa Ashok Hora, that a new ground of palpable error which has been introduced by the Supreme Court in the DMRC case, whether such an approach is correct or not. Again, you are free to either sort of be for the judgment or against the judgment. And if I were an examiner, I would always appreciate if you are able to give your original thoughts. Now, the next judgment is a judgment of Nandini Sundar versus State of Chhattisgarh. Now, this is a judgment of a division bench, but it assumes significance for the reason that the case concerned the escalating violence in the Dantewada district in surrounding regions of Chhattisgarh, which was on account of Maoist Naxalite insurgency and the counter-insurgency operations by the state. The petitioners, including prominent academicians and human rights activists like Nandini Sundar, challenged the legality of Salva Judum, a state which was perceived to be a state-sponsored civilian militia, and the appointment of special police officers by the Chhattisgarh government to combat the Naxalites. Now, the petitioners alleged widespread human rights violations, including forced displacement, torture, killings, use of children in armed conflict, all committed by or under the aegis of Salva Judum and these special police officers. They argued that the state was effectively outsourcing its law enforcement and counter-insurgency functions to the untrained, often illiterate and poorly paid tribal youth, thereby violating their fundamental rights in the use of law. Now, the issues raised was whether the appointment of these special police officers and arming of the civil vigilante groups like Salva Judum by the state of Chhattisgarh violated the fundamental rights of citizens under Article 1421 of the Constitution. And the state, whether the state has the power to delegate its core policing and law enforcement functions, and whether it amounted to violation of international humanitarian law and human rights norms. Now, in this judgment, Salva Judum and SPOs were declared unconstitutional and illegal. The Supreme Court unequivocally declared the Salva Judum and appointment of SPOs for counter-insurgency as unconstitutional and illegal. And it also held that it was a clear violation of Article 21. For civilians, the action of Salva Judum, including forced displacement, violence, and creating an atmosphere of fear, amounted to a severe infringement of the right to life and dignity. For SPOs, the special police officers, the court observed that appointing often illiterate or barely literate tribal youth as SPOs, arming them and sending them, into dangerous counter-insurgency operations and without proper training or security amounted to treating them as a cannon fodder. This violated their right to life and dignity under Article 21, as they were incapable of understanding the true dangers or making informed choices. And then it also delved upon the issue of Article 14, right to equality, and held that appointment of young, uneducated tribals as SPOs and placing them at the same level of danger as regular police who have better training and educational backgrounds was discriminatory, and it violated Article 14. Now, it also pointed on the state monopoly on law enforcement and policing and held that it is clearly a non-delegable and exclusive monopoly over law enforcement and maintenance of public order, which could not be outsourced, or the state could not abdicate this core sovereign function to private individuals or vigilant groups. It held that the state's action was seen as an unlawful delegation of its constitutional and statutory responsibility. Now, it made a host of directions against the state of Chhattisgarh, which you will have to actually read the judgment to see, which basically delved on the use of SPOs. It said you can't use SPOs. It said you recall firearms. And then it says that you have to protect the former SPOs. You must have regular police force. You must vacate schools and hostels where security forces were occupying. And it also directed CBI investigation for alleged criminal offenses committed by Salva Judum and Naxalites, both. So it's a landmark case insofar as human rights in conflict zones are concerned. So it's a seminal judgment safeguarding human rights in the context of internal armed conflict. It sends a strong message that state cannot resort to unlawful means, even when confronting serious threats to national security. This judgment is a clear affirmation of rule of law, and it also protects vulnerable groups. So it is also a stark reminder on the Supreme Court's interference to limit state power. So, thank you. My next judgment is Sita Soren versus Union of India. It's again a very interesting judgment. So this is also recently delivered by a 7 judges constitution bench. Now, in this case, Sita Soren was a member of the Jharkhand Legislative Assembly from Jharkhand Mukti Morcha. And she was accused of accepting a bribe in 2012 to vote for an independent candidate in the Rajya Sabha elections. Now, the allegation was that despite allegedly accepting the bribe, she eventually voted for a candidate from her own party due to the open ballot system in Rajya Sabha elections. Now, criminal charges were subsequently filed against her under the Prevention of Corruption Act. Now, Ms. Soren approached the Jharkhand High Court seeking to quash the criminal proceedings. Her principal ground was immunity from prosecution under Article 194(2) of the Constitution. She relied on the Supreme Court's earlier judgment in P.V. Narasimha Rao versus State, which had held that the legislators who accepted bribes and then voted or spoke in the House as agreed were protected by parliamentary privilege under Articles 105(2) for MPs and 194(2) for MLAs. However, those who accepted bribes, it's a very interesting proposition, but did not vote or speak as agreed, or bribe givers were not granted such immunity. The High Court dismissed her plea, reasoning that since she did not vote as per the bribe, she did not enjoy the immunity. Now, Sita Soren then appealed to the Supreme Court. Now, initially, a 5-judge bench heard the matter, and finding the correctness of P.V. Narasimha Rao judgment doubtful, referred it to a 7-judge bench for reconsideration. Now, the core issues raised were whether a member of parliament or member of legislative assembly enjoys immunity from criminal prosecution under Article 105(2) or 194(2) of the Constitution for accepting a bribe to cast a vote or make a speech in the legislature. Now, the second issue was whether the offense of bribery under the Prevention of Corruption Act is complete upon the acceptance of bribe, irrespective of whether the act for which the bribe was given was performed or not, and whether the principles of stare decisis should prevent the Supreme Court from re-examining or perhaps potentially overruling the P.V. Narasimha Rao judgment. Now, as most of you would know, that stare decisis is a very good principle which says that you must have adherence to precedents. So long-standing precedents must normally not be upset, which have held the field for a long time. However, stare decisis is not an absolute principle. If a judgment is wrong, it can be overturned at a subsequent stage. As societies evolve, the laws evolve with the society. So the unanimous opinion in the 7 judges case was that there was no immunity for bribery. So it clearly and consciously overruled the P.V. Narasimha Rao case. It held that immunity granted to the legislators under Articles 1052 and 194 of the Constitution does not extend to criminal acts like bribery. It clarified that accepting a bribe is a criminal offense, independent of any parliamentary conduct and not protected by legislative privilege. It then went on to the purpose of privilege and emphasized that the purpose of privilege is to ensure that there are free and fearless functioning of legislative bodies, allowing members to express their views and cast their votes without undue influence or fear of legal repercussions. And what is very important is, please note it, for their legislative acts. This immunity is crucial and robust for democratic deliberations. However, this immunity cannot shield any criminal for a criminal act like bribery, which fundamentally undermines the very essence of parliamentary democracy and probity in public life. It interpreted in respect of and held that in respect of anything said or any vote given in Articles 195, 1052 and 194.2 to mean arising out of or bearing a clear relation to the genuine legislative functions. It rejected a broad interpretation that would encompass actions preceding or external to actual speech or vote, such as the act of accepting a bribe. The act of bribery itself is distinct from the legislative act of speaking or voting. It then further held that bribery is complete upon acceptance. It clarified that under Section 7 of the PC Act, the offense of bribery is complete the moment a public servant, which includes a legislator, obtains, accepts or attempts to obtain an undue advantage with the intention to act or forbear from acting in a certain way. It is immaterial whether the actual promise for which the bribe was given is performed or not. Now, this interpretation reinforces the anti-corruption framework, preventing perpetrators from escaping liability by failing to deliver on the correct bargain. Then it held that the principle of stare decisis is not absolute. It laid down a twofold test for legislative immunity. It said that when can immunity be claimed? The act for which immunity is claimed must be related to the collective functioning of the House. Point number one. Point number two, the immunity sought must bear a functional relationship to the discharge of the essential duties of an individual legislator. Bribery fails this test as it is not an essential or functional duty of a legislator. So this judgment is extremely significant because it also tends to weed out corruption in the House, which would obviously lead to strengthening the rule of law, and it would also restore probity in public life. This judgment reaffirms constitutional values, and this is really a judgment goes towards evolution of parliamentary privilege. It redefines the scope of parliamentary privilege in India, aligning them more closely with the functional necessity of the legislative work rather than extending them to cover criminal acts. Now, when you are dealing with this judgment, if you have, and be that as it may, I mean, I really want you to read and also use the famous judgment we have, which is State of Tamil Nadu versus the governor. And this judgment obviously has created ripples in the judicial as well as the political circles. But having said that, this judgment reinforces many things. One is the concept of a very interesting phrase of pocket veto has been used, which basically says that the governors cannot withhold consent, assent ad infinitum, and in case of reservation of bills for the consideration of the president, contrary to the advice of the State Council of Ministers, the governor shall make such reservation within a maximum period of 3 months. So this outer limit of 3 months has been prescribed. Now, again, I would want you to apply your own mind. You may again write a small critique or a small affirmation insofar as this judgment is concerned. But while dealing with the judgment of Sita Soren, I would say that this would also be like a forward reference. This would also be a forward reference to wherever you're dealing with the power of the court under Article 142. So this would be an interesting reading. So I think this concludes my lecture. So I would hand over the mic back to Mr. Amit Sharma or Mr. Aditya Giri.
Aditya, are you there?
Yeah. Thank
Sir,
you.
I've been informed that you are having a flight back to Delhi.
Yes.
And looking at the short timeline, I would directly would want to give a vote of thanks to you. And in fact, 2 questions I saw which pertains to asking important paras from these judgments. But I personally believe that they should themselves go through the entire judgment based on the synopsis and crux we have provided to them. So on behalf of the entire executive committee of SCAORA, I, Aditya Giri, member executive, extend a sincere vote of thanks to you, Anupam sir. Despite your packed schedule between court hearings and this untimely court hearings, in fact, and your flight back to Delhi, you have graciously covered the 5 landmark judgments while tracing their jurisprudential evolution. And your scholarly exposition will prove immensely beneficial for the AOR aspirants. We are profoundly grateful, sir, for your valuable time and invaluable insights. And thank you for this enlightening session, and wish you a safe journey back to Delhi, sir.
Thank you so much. All the best to all the aspirants. Do well. Thank you. Thank you so much.
Thank you, sir.